Hello, good morning, everyone. Thank you so much for joining us. Jeff and I wanted to team up and answer questions for our clients and our friends about employment law and insurance. My name is Cindy Flynn. My firm is Hackler Flynn and Associates, and we practice employment law, defending and protecting business owners only. Jeff, would you like to go ahead and introduce yourself?
Yeah, hello everyone. As Cindy alluded to, I'm Geoff Johansing. I am a property and casualty insurance broker working with Insurance Office of America in our Pasadena office. And looking forward to our conversation with you all today regarding getting back to work in the COVID era. So Cindy, you and I have spoken quite extensively on this topic, and I know we share clients and you have clients with regards to what's going on. I'd like to open up to everyone on this call that this is a Q&A. So if you have a question, please feel free to reach out or post a chat, and Cindy will read off the question, and depending on what it's related to, either Cindy or I will answer it. So Cindy, I've heard clients talk about the frustration that they have with what's going on and their inability to get employees back when they're open. Have you heard that, or any idea of what they're experiencing on that realm?
Yes, definitely. We've had a lot of our clients say that they have employees who are currently on unemployment and they don't want to come back. And part of that has to do with, the federal unemployment is an additional $600 a week, which means that if your employee is getting $1 on state unemployment, they get an additional $600 a week from the feds. And this has become a huge problem for a lot of our clients who have minimum wage earners on their payrolls.
Yeah, because they're making more on unemployment than they would with being back in business. So what can employers do with regards to that? We got employees that I want to have them back. What do they do in that instance? What can they do?
The bottom line is to remind your employees that unemployment is, of course, temporary, right? The $600 a week is supposed to end at the end of July, so July 31st, 2020. And it's also important to note that if you have work for your employees and you call them back to work and they refuse, then they are no longer eligible for unemployment insurance benefits. I do want to caveat that response that if an employee has a potential medical issue, which would implicate disability accompanying, we would recommend you consult with counsel. So yes, one of the questions here is, if an employee notifies us that they have tested positive for COVID-19, what are our responsibilities regarding contact tracing and maintaining employee confidentiality? That is a great question from our audience. And so the bottom line is that you have to keep that employee's medical record or any sort of medical history confidential. You also do not want to tell other employees who got sick and who was diagnosed positively for COVID-19. Obviously, if you're a small firm and you have 5 people and you meet every Friday on Zoom and you say to your staff, who's now 4, somebody got sick, they're going to be able to figure it out, but you still have that duty to maintain confidentiality with respect to that employee who does test positive for COVID. Jeff, if you do have employees who are coming back to work, what are some of the best practices you're seeing in order to make sure that your business is properly sanitized?
So I'll tell you what IOA Corporate is doing. They have done a deep cleansing of their facilities where there's 10 plus employees. So everyone is out. They're timing when people can come in and pick up mail and that sort of stuff, but they're not allowed back into the facility. They're implementing a return to work plan, but they've done a deep cleaning. Here at WeWork, where I am, there's a staff continually walking through the facility and wiping down the handles, the doorknobs, and all that sort of stuff. Things you may not think about as you're opening, or you have people in the office, or the coffee pot, the water cooler. And think of what's in the kitchen that commonly gets used. And you want to just minimize that or get rid of it. Here at WeWorks, they do not have coffee service anymore. They have a water cooler that again is continually wiped down and that sort of stuff. If you were to look at a manufacturing facility, you want to address the issue with regards to sharing tools, hand tools, be it a pneumatic pump or something that you're sharing amongst each other because you're not using it all the time in a line of assembly. So stuff like that, you know, wipes, hand wipes and sanitizer and all that stuff spread throughout in common areas for people to use, I think is another good practice and should be adhered to. It just, you know, want to be able to have employees be able to keep themselves, their hands clean and what have you after they've touched stuff and what have you. So Cindy, you know, we've gone through this. Okay, now let's say my place is really clean. I've done a great job cleaning it. But now we've got this issue where I've got employees back at work, and now I've got an employee who's tested positive for COVID. Can you tell me how workers' compensation affects that?
Yes. So on May 6th, our governor, Gavin Newsom, issued an executive order which creates a temporary workers' compensation presumption for employees diagnosed with COVID-19. And this presumption is retroactive to the date of the stay-at-home order, which of course was March 19th, 2020, and it will stay into effect for 60 days after its effective date, which is through July 5th, 2020.
What orders need to be met to have the presumption then, that an employee?
So, yeah, it's 4 things. 1, that the employee tested positive for or was diagnosed with COVID-19 within 14 days after a day that the employee essentially worked at the employer's place of employment at the employer's direction, right? Number 2, that the day on which the employee performed labor or services at the employee's place of employment was within that specific time frame on or after March 19th, 2020 to today, or all the way through July 5th. 3, that the employee's place of employment was not the employee's home or residence. And 4, that the diagnosis was done by a physician who holds a physician and surgeon license issued by the California Medical Board, and that diagnosis is confirmed by further testing within 30 days of the date of the diagnosis. So under this executive order, any COVID-19 related illness shall be presumed to arise out of and in the course of the employment for purposes of awarding workers' compensation benefits if all 4 criteria are met.
So does the presumption come into play if you haven't asked the employee to come back to work?
So no, the presumption does not cover employees who went to their place of employment without the employer's direction. So if an employer doesn't say you can come back and the employee does anyways, that would not count. And the presumption is really meant to cover any employees who must work outside of their homes during the stay-at-home order at the employer's direction. So while all essential workers who were required to report to work are covered, the presumption also covers any non-essential workers who performed labor or services at the employee's place of employment at the employer's direction.
So, you know, one of the difficulties with this is having to prove something didn't happen. So what if you can prove that the employee did not get COVID at your facility?
So the presumption is a rebuttable one, which means that, you know, you turn it into your insurance carrier, let them handle it. I'm sure Jeff can help with that if you are one of Jeff's clients or if you want to be one of Jeff's clients. But the debate will be whether or not it can be controverted by other evidence. So an employer could rebut the presumption with any evidence that the employee contracted COVID-19 outside of the course of employment. And Jeff, I was just wondering if you think this presumption is going to have any effect on how rates are calculated for your clients.
So the claims that are related to employees contracting COVID that go through the system will not be included in the experience modification calculation. But I believe that carrier rates are going to go up, although they're not going to be included in your XMOD calculation. These claims were never intended to be covered under workers' compensation, so the carriers haven't charged for them. And I would say it's similar to an employee getting the flu at work. That's not covered under workers' compensation. So I foresee a continued hardening of the market where rates will go up, not due to an increase in your experience modification, but because of overall market conditions. So Cindy, how can employers help reduce these risks? What recommendations do you have for employers to minimize their exposure?
Yeah, and I was just talking to another law firm this morning about this. I mean, we're really recommending that if you're able to, have your remote workers work remotely for as long as possible. Of course, you have to follow all OSHA and CDC guidelines for employee safety. Additionally, I would recommend reviewing all local and county regulations to determine if there are any specific guidelines in place that you need to follow. What protocols, Geoff, have you seen IOA put in place, and how are they implementing them?
IOA's got their employees coming back in stages, and the stage, it's a 2-month process overall. We, as all employees or 1099 employees of IOA, have to sign off that we agree and will adhere to all of the protocols that they put in place. I shared with you earlier that they've done a deep cleaning on all of the facilities. We had to sit through webinars, and it's recording whether or not we participated in them. And there's just a lot to do. There's a lot to it. So it's just in your best interest as an employer to adhere to the regulations, so that in the event that you find a claim or something happening, be it a third party or an employee, you have documented what you're doing for the presumptive rebuttal. What effective ways are you seeing that employers can use apps or check-ins or meetings and that sort of stuff to make sure that their employees are staying productive and healthy, et cetera?
Yeah, this is one of the biggest things we see companies struggle with remote workers. I mean, obviously you want to use all resources available to you, right? Text, phone, email, to stay in touch with your employees. You do want to make sure you are doing those things during work hours so that your employees can't come back later and say like, oh, I was getting texts at 9 o'clock at night and therefore having to respond and therefore, wasn't paid for that time of working. So you want to be a little bit careful with that. Scheduling regular check-ins can be particularly helpful. I know some of our clients use Uber Conference, which basically allows you to set up a phone call every day or every week, and it will call all people on the conference line at the same time. So I think this company does it every morning at 9:16 a.m. So everybody gets on the phone and they do their sort of 1-minute huddle. What are the things that you need help with for today, and what is the overall attitude or feeling or something like that, just to touch base with everyone, get a pulse for how your staff is doing. Online meetings like Zoom and Microsoft Teams are also really helpful. Because as we can't come into contact with each other, things like Zoom and Microsoft Teams might be helpful to keep your employees from feeling isolated from one another. Also, we have clients using Slack or things like that where there's an instant message chat back and forth. Those are sometimes fun to pull later on about what your employees really talk about. But yeah, so that's something that we see our clients do.
I know that there's some people on this call, and I would like to reach out to them and get some input on them as to what they're doing in their companies with regards to regulations and keeping people safe. So Philip Keel, I see that you're on this webinar, and if you would, do you mind sharing some of the stuff? I know you guys are doing a great job with regards to keeping the employees safe, and what have you found to be beneficial, and maybe some areas that you could share that you struggled with figuring out how to comply with?
Someone says, we've been doing our best to protect employees at work and at home. We provide supply masks, safety glasses, hand sanitizer, and alcohol wipes for use at work and at home. And Jeff, I think that's from Philip, who you called out earlier. So Philip, thanks for sharing what you're doing. It looks like it's in line.
So Cindy, kind of in a line with the question that I asked you, what about with regards, what are you seeing best practice wise with the remote staff and making sure that they take their required breaks and lunch and that sort of stuff? How does an employer address that?
So, you know, you want to make sure you're having them fill out time cards regularly, right? I mean, you can do a simple email and chat. What we would recommend, though, is probably an Excel spreadsheet. It doesn't have to be anything fancy, just something that allows you to find out when your employees are taking breaks and lunch breaks throughout the day. You know, you can have them turn it in every other Friday or every Friday or every day or whatever that looks like. You want to address any irregularities with employees and counsel them or discipline them if appropriate. I was just on the phone with another law firm this morning, and she was saying that she had an employee whose time records just didn't match what she was looking at on the work front of how many hours a week she was working. So she ended up having to terminate this employee. But we are definitely seeing that. And then we've also had clients, Jeff, over the years ask about, you know, screen monitoring, if you can take snapshots or keystrokes for apps. I mean, there is a way to do this legally, but you really want to tread carefully here. You know, if your employees are on computers that are owned by the company, you can monitor screens, but you want to make sure that your employees are notified in advance. And I would recommend a privacy policy in place, especially if you have workers working remotely, because these employees are at home. They have an expectation of privacy in their home. And if they're using their own computers, it might be a little bit different. Definitely consult with your legal counsel, whoever it is, or reach out to us. I'm happy to help in any way there. And then, Jeff, what do you think about notifying your workers' compensation carrier if you have remote employees?
With regards to employees working remotely, there's now another workers' compensation insurance rating bureau recommendation, and that's that they be classified under clerical, which is individuals that are working at a computer. So let's say you've got your warehouse staff, and they're not warehousing, they're not in the warehouse, they're at home. And for example, they could be setting up their catalogs, your catalogs online and that sort of stuff. So instead of classifying them as you would normally in the warehouse classification when you report to the carrier, you would classify them during this term that we're in under 8810, which is the class code for clerical staff, which is a lower rate and reduced premium based on that. So, you know, we're getting back to work, and let's say now we've got an employee and they have COVID or they have a fever, Cindy. So in this circumstance, what should employers do with regards to that?
So, I mean, if an employee gets COVID or even if they have a fever, you know, we recommend that you send them home or have them remain at home. You want to follow current CDC recommendations, which changes pretty much weekly. And you also want to keep in mind that you would probably have to pay them or you would pay them, assuming you don't meet the very narrow exception. But under the Families First Coronavirus Response Act, there's the emergency paid sick leave for up to 80 hours. So you want to keep in mind with that.
And for those of you on this, George has shared with us also, he's got a client that has a app that is able to take an employee's temperature quickly. So George shared that. Thank you, George. Also, with regards to that, so, you know, taking the temperature of the employees, what kind of regulations
you know, 6 months ago, we would have never have said to take an employee's temperature, right? Like, absolutely not. That's considered a medical examination. However, the EEOC has issued guidance that taking an employee's temperature is permissible, but also following local and state guidelines and CDC, of course, by implementing social distancing measures, wearing appropriate PPE, implementing additional sanitation procedures, those types of things. And I think what George alluded to here is, you know, this camera that can take an employee's temperature in 1 second with no touching. It's set up at the front of the building. A control person in another location sees the person in front of the camera. If the temperature is okay, the control person sees a green border. If the temperature is high, the border is red. The people around the person don't know the results, so privacy is protected. People with high temperature are privately advised of the situation. And so that comes from George Salmas, who's a food attorney, a good friend of Jeff and I. So maybe George, if anyone's interested in hearing who that company is, maybe we can do an introduction or something to see if we can get some of our clients and friends help with employee temperatures. So George, thanks so much for sharing that. And we have some additional comments, Jeff, from Philip about having plexiglass barriers in high traffic areas, and that they do extensive cleaning and also providing alcohol wipes to all employees so that they can clean their own tools and workspace. So thanks, Philip. Those are great tactics to keep in mind.
Yeah, you know, and I'd say having that sort of stuff available around, well, I talked a bit about the kitchen, but you know, you've got the copier, you've got common areas, the reception area where customers and third-party vendors may show up to do deliveries or what have you. So just have the sanitation stuff in those areas. I've heard with regards to other employers, there's one place to come in, there's one place to go out, the two don't mix, so you've got ingress, egress. So depending on the type of industry you're in and your setup, your physical layout for your facility, there's a California state website, it's called Resilience Roadmap, and it really does a great job in identifying the various areas that you need to address and how to do it. You can drive down all the way to specific industries. It's large groups of industries. For example, manufacturing is one. Schools or common, like a church and schools would be put together. But there's a lot of really good resources out there. There's good vendors like what George shared with regards to people that are able to take, have created technologies that can take temperatures.
And Jeff, can I just interrupt you? Sorry, for one more thing on the temperature thing. I do want to make a note that, you know, taking an employee's temperature is really limited to the purpose of evaluating the risk that an employee's presence poses to others in the workplace as a result of COVID. So this may not be a practice that is around for a long period of time. And then getting back to a question a little bit earlier, you want to balance HIPAA obligations, right? And your ethical obligation to other employees. And I haven't seen anything yet that mandates notifying your employees if someone does test positive. A lot of the guidance is framed in a manner that appears to be a permissive standard for employers, allowing you to choose what's appropriate under the circumstances. However, I am aware that there are local health departments which are more effective at contact tracing positive tests. It would be better for employers to get ahead of the game and notify their employees. And in that regard, if you go that route, employers are only permitted to notify impacted employees in a way that does not reveal their personal health related information of an employee. And then just one more note, Jeff, before we wrap up. The DFEH has specifically provided the following suggested language for you to utilize in an email, and you can pull that information, or I'm happy to to send it to you, but it basically says that the employer has learned that an employee at this office location tested positive for COVID, and the employee received positive results on this day. This email is to notify you that you have potentially been exposed to COVID-19 and that you should contact your local public health department for guidance and any possible actions to take based on the individual circumstances. The DFEH also says that you could have this conversation in person, but the downside, of course, is that it lends itself to inadvertently providing more information about the COVID-19 positive employee than you're legally permitted to provide, right? Like the health status of how he or she is doing or any information like that. And yeah, so I just wanted to make note there. Thanks, Jeff.
So, you know, I want to thank you for joining us. If there are any other questions, feel free to reach out at any time. It's a very fluid thing that we're going through, and the regulations are changing, and I foresee the courts being pretty full, trying to figure out what's going on and who's, you know, the business interruption and who's liable for this and that sort of stuff. But I just urge you to follow the regulations, the strictest ones that apply to your organization, to do what you can with regards to the presumptive rebuttal, and reach out to us. We, both Cynthia and myself, have a lot of resources with regards to services and professional organizations that can help you through this. Cindy, do you want to do the legal disclaimer?
Oh, yes. Thank you for reminding me that content on this webinar is not considered legal advice. It's for informational purposes only. And, you know, we are always happy to create an attorney-client relationship, and I'm sure Jeff is happy to create an insurance relationship with you as well. So please reach out to us individually, but nothing on this webinar is considered legal advice, only for informational purposes only.
All right. Thank you, everyone. Have a wonderful day. Stay safe.
Thank you.
Bye.